Yana, we appear on behalf of the accused, Miss April Morris. Yana, the accused, were charged with 4 different offenses, including 3 summary offenses being assault, being foul drunk, damaged property, and 1 indictable offense being causing injury. The accused is being held in custody, and we understand that the police are opposing her bail application. Yana, Section 4 of the Bail Act provides that anyone held in custody on the basis of being accused of an offense is entitled to bail unless the law requires such bail to be refused. Yana, this bail application does not fall within the categories prescribed under Section 4AA of the Bail Act, where there is risk of terrorism, or the accused were charged with offense prescribed in the Schedule 1 or Schedule 2 of the Bail Act. Therefore, the accused does not have to demonstrate exceptional circumstance or compelling reasons to justify the grant of bail. Yana, in this case, it is up to the court to consider surrounding circumstances and determine whether there is an unacceptable risk to grant bail to the applicants. The Yana unacceptable risk as defined at Section 4E of the Bail Act being the situation where the accused might do the runner, commit another offense while on bail, endangering the safety or welfare of other member of the public, or interfere with witness, or otherwise obstruct the course of justice, whether it's related to this matter or another matter. Yana, in assessing the risk that the accused might be on the run, we look at the fact that in terms of the property ties, the accused is making more than $125,000 per year in marketing. She shared a saving of $50,000 and property that worth $75,000. Yana, during the incident, the accused caused damage to the property, which is more than $3,000 in value, and this is 1/40 of her net property. We submit that the accused has been a useful member of the society, and she is now, even now, she's being charged for her misconduct. The accused has all the reason and capability for potential rehabilitation. We understand that there might be concern of the fact that the accused had a commercial pilot license and that she's not in a close relationship with her parents. Now, in terms of the family tie, however, we have today in the court Ms. Morris's partner, who is here to support her bail application. The accused is a social media influencer, and she's well recognized by the public. Therefore, we submit that it's not easy for her to do a runner. Yana, in assessing the risk where the accused might commit further offense, we submit that this offense is completely out the accused's character. This is the first time she was charged with offense that is violence in nature. In fact, the only issue that she ever had with the police was the driving offense, which was more than 5 years ago, and there's no conviction was recorded for that incident. Yana, the accused, commits the offense under the influence of alcohol, or in the other word, all of these damage could have been avoided had the accused was in her right state of mind. Yana, in assessing the risk where the accused might endanger others, we look at the fact that she's 5'9" tall. She has a black belt in Zendo Kai with 4 years of practice. Having said that, Yana, this why this indicates that she is capable of causing harm to others. The alleged offense has been the only violence incident the accused has ever involved, and there's no suggestion indicate that the accused will be involved in another incident in the future. Yana, in assessing the risk where the accused might interfere with witness or obstruct the course of justice, we took into consideration that the evidence is that she's some of the accused's childhood friends are associated with crime gang, and one being the president. We instruct that the accused has not been in contact with these friends for many years. We further instruct that the accused is also prepared to plead guilty at the first chance. To sum up, Yana, it submits that the accused is not an unacceptable risk as defined at Section 4E of the Bail Act. Yana, Section 3AAA of the Bail Act requires surrounding circumstance to be taken into account we concede that the offense is serious and the prosecution has a strong case against the accused. In fact, as mentioned earlier, the accused is prepared to plead guilty to all the charge. This is the first time the accused were charged with violent-related offense. There's no history of breach of bail condition. There's no pending or ongoing criminal matter around the time of this offense or around the time of this hearing, Your Honor. The accused had a job in marketing, which will be interrupted and negatively affects if she's incarcerated. The accused has a special medical condition, being allergic to penicillin and suffer from hay fever. We submit that being incarcerated might contribute to her health deterioration. Lastly, there is a risk that the accused might be mistreated while being in custody for being a homosexual person, Your Honor. Pursuant to Section 5 of the Bail Act, we propose that the accused to be released on bail with the undertaking of the following condition of bail. First, the accused must pay a bond, security bond of $50,000, must surrender her pilot license and passport to the police, must not leave the state of Victoria, must not approach any international points of departure, like an airport or seaport, must not consume alcohol while on bail. She must report as requested and subject to alcohol test. She must stay away from drinking places, must not associate with individual or organization that involve in criminal conduct, must not approach or remain within 5 meters from the victim, and must not attempt to locate or contact or communicate with the witnesses. Your Honor, that concludes my submission.